Hello and welcome to Analysis with me, Jonathan Steele. Abdul Quader Mollah, a leader of the Bangladeshi opposition party, was hanged last Friday in a jail in the capital Dhaka. The Supreme Court considered him guilty of several war crimes committed during the 1971 War of Independence from Pakistan. His original life sentence had been overturned by the Supreme Court in September, after mass protests called for him to be hanged. Mollah is one of 5 opposition leaders condemned to death by Bangladesh's International Crimes Tribunal, set up in 2010 to investigate atrocities perpetrated during the 1971 conflict, in which 3 million people died. But for many analysts, the trial was just a way to promote political interests and eliminate an opposition leader. Critics say that the tribunal was used as a political tool by the Prime Minister. Mollah's party has already said that people would revenge his execution by deepening the role of Islam in Bangladesh, and they've called for a nationwide strike. So was it a political trial or a fair trial? Has the court surrendered to public pressure? And what are the implications for the elections due early next month? To discuss all these issues, we invited Stephen Kay, co-chair of the War Crimes Committee of the International Bar Association, who's defended some of the opposition leaders, Murad Qureshi, a member of the London Assembly for Labour, and on Skype we have Brad Adams, who is Executive Director of Human Rights Watch's Asia Division. But before we start our discussion, let's watch this report by Tiana Simons.
Last Thursday, Abdul Quader Mollah became the first person to be executed after being convicted in Bangladesh's International Crimes Tribunal. After months of appeals, prominent opposition leader Mullah was sentenced to death by hanging for war crimes he committed during the 1971 War of Independence. Originally sentenced to life imprisonment, his verdict was changed to execution by the Supreme Court in response to countrywide protests demanding the death penalty. The tribunal was set up in 2010 to investigate abuses committed during the war, which is estimated to have killed up to 3 million people. But human rights groups have expressed concern that the court falls short of international standards. In a letter to the Bangladeshi Prime Minister, Sheikh Hasina, Human Rights Watch said that although they are pleased that a special court has been set up to address these crimes, we believe that additional amendments to the Act and rules are necessary to ensure that trials are carried out in accordance with Bangladesh's international human rights obligations, international criminal law, and Bangladesh's constitution. However, the ICT have defended the validity of the trial.
As a prosecutor of this International Crimes Tribunal, I'm very particularly, we think that we have done the process and the trial process very fairly, and we have followed the international procedures. So it was totally an open trial, and justice has been done to the victims of those who have lost life during these atrocities done by these perpetrators.
4 other leading figures in the Jamaat al-Islami party have been sentenced to the death penalty. Whether or not the trials are lawful is a highly contentious question in Bangladesh and internationally. But with public pressure in the run-up to the elections, it seems that justice is a complicated question. Tiana Simons, Islam Channel.
Well, Stephen Kay, you've acted as a defence counsel for Abdul Quader Mollah and the other defendants in this trial. I mean, what's wrong with the trial? We heard somebody there from the prosecution side saying it was completely fair, etc.
Yes, and I noticed he couldn't really look at the camera when he said completely fair, and I noticed that he hesitated over his words and couldn't actually get them out to say that it was a fair, internationally acclaimed trial, because the plain fact of the matter is it is not. And at the start, when you said, has the court surrendered to political pressure, the court was never created without political pressure. So I'm afraid you have to go right back to the beginning and not the end of the story. This was a court that was established in a way that excluded all defence rights from the Bangladesh constitution for anyone put on trial before the International Crimes Tribunal. So it was established outside the usual norms for any citizen within Bangladesh when they expected
no, but you
a
are
fair
a defence
trial.
counsel. There is a defence and so on, and people can appear in court on behalf of the accused, can't they?
We were actually denied permission to appear in court on behalf of the accused. The original rules for the tribunal did establish that foreign counsel would be permitted to the defence. But the plain fact of the matter is that when it was realised that there were genuine international defence counsel who would appear on behalf of the accused, the rules were changed to prevent that. Now, this court, when it came into being, having never been used for 40 years, had significant problems in its architecture and structure. It had problems over the fairness provisions relating to trials, and it had problems over the establishment of the judges who were to take part in the tribunal and decide the trials. And it never got beyond those initial problems.
Well, we'll come on to a lot of the particular points a bit later, because I know Murad may have to leave early. You are much more of an expert on the political side than the legal. Your father was a fighter in the Bangladeshi Liberation War. I mean, do you accept the idea that it was actually it is a political court, basically?
Well, let me just talk the political context. You know, the War of Liberation is something that's it's still in the living memory of most relatives. You know, you talk to grandparents, you talk to mums and dads, they will recollect what they did and didn't do. And it was actually a major political issue, not only at the time, but also in the last general election in Bangladesh in 2008. It was one of the reasons why I think the Army League got the majority that it did at the time. And I feel that you can safely say that there was a political mandate to once and for all deal with this. It's a bit like war criminals from Second World War, Nazi ones still in their 80s and 90s being pursued, and rightly so. So that I'm clear in my mind that needed to be done, because I think it is an albatross around the neck of the Bangladeshi psyche that needs to be dealt with. How it's been dealt with is not really something I am going to express views on, because I'm not a lawyer. I'll just make one or two observations. The Supreme Court has shown itself in good lights in other things when they've represented British subjects who have been, for example, forced marriaged, and we've had the British High Commission using the Supreme Court to defend those people, and I thought it came out very well. This may not have been an instance where they have done, and I do think it's a sad day when something like this happened at the same time as last week when we had Mandela's passing away, and I think there are lessons to be learnt in the Bangladeshi political scene from what happened in another part of the world.
But there should have been more sort of reconciliation, willingness to forgive, so on,
exactly. I mean, I think there are. I mean, sometimes the law gets in the way, is my view. I think there are things that the South African regime, after the downfall of apartheid, did very well. The reconciliation committees that they set up dealt with a lot of atrocities in apartheid are much better than I think the legal system can do. And that's the kind of thing that I think works much better, would work much better in this context, rather than this kind of legalistic thing, which quite honestly loses a lot of people when you get into the heart of it, really. And may have lost people watching this programme now. At the same time, you know, I'm not a defender of the death penalty, but I do know if I was advocating the death penalty in Britain for a referendum, it's more than likely to be brought back in, and it's not. And it's similarly popular out there, as well as next door in India with the gang rape last year. The popular demand there in Delhi is that the gang rapists should all be strung up. So I just think that's the context we're dealing with a lot of this. And I think there's just a few faults which I think hopefully shed some light on how it's seen, I think, from what I'm hearing from relatives and when I go through there regularly once a year.
Well, Brad Adams, you there. Let me come back to the issue of the fairness. I mean, Murad is making the point that, you know, there were terrible war crimes committed and this should be looked into by the law. But would you say the people who've been chosen, they haven't been chosen, but the people who've been made the accused Are they all from one side of the argument? Weren't there atrocities on many hands and many counts? And if this was really about, justice, wouldn't you see people not just all from one political party being put on trial?
Yeah, I hate to do this to you, Jonathan, but take one step back further, please, which is that the main perpetrator here was the Pakistani army. It was able to negotiate with American support, Nixon and Kissinger in particular, and essentially an amnesty for itself between the new state of Bangladesh and the new state of Pakistan, because the United States wanted to protect Pakistan. And so the people who are available for prosecution are Bangladeshi citizens, but not the architects of what happened there, although some of the people who are accused would have possibly had very important roles in the atrocities that were committed there. And I'd also just like to endorse what the last speaker said, which is that if you go to Bangladesh, and I go there all the time, people really want justice. It's something that people talk about, and it cuts across the political divide, except for the Jamaat Party, which is the third largest party in the country, and probably would get less than 10% of the vote in an election. But even the supporters of the Bangladesh Nationalist Party tend to want justice, and in fact, many people in the human rights community haven't been happy with Human Rights Watch speaking out on these trials because they see us as obstructionist, even though, of course, we are simply calling for international standards. And to answer your question directly, Jonathan, the people who are accused are largely from the Jamaat Party. There also are accused from the Bangladesh Nationalist Party, and there is an Awami League accused. And there is talk of more people from the Awami League being accused. But before this trial actually started, I met the prosecutor, the chief prosecutor, and I met some. Basically said, before we've done any investigation, we know who committed these crimes. It's going to be really easy. To which I said, you are taking a major risk here because you must present proper evidence in court. And while we are in favor of justice, as we should be as a human rights group, if you do not follow fair trial procedures, if you do not produce credible evidence in court, we will complain. And more to the point, you will make martyrs of the very people you think were responsible for these atrocities. And as Stephen said, the trials have not produced credible evidence. They've been based on bad laws, bad procedures, the exclusion of defense witnesses, the list goes on. And they have now managed to make someone like Mullah a martyr. I don't know whether he was innocent or guilty, but many, many Bangladeshis think he was guilty. The problem is the evidence wasn't produced in court.
Well, how come? I mean, it's one thing to exclude defense witnesses, and obviously that's very bad, but the prosecution must be able to come up with some facts if so many people were killed.
This court has been a creature of the politicians from the moment it was brought alive in 2010 after the election. It was a successful campaigning mechanism for the Awami League party, and then when it was implemented, resuscitating the 1973 International Crimes Tribunal Act, it then became a creature of the politicians into how it was implemented. The first president of the court was a judge who had been part of a commission of inquiry to find these people guilty in 1992. This judge was also accepting outside direction from third parties in something that was revealed by leaked conversations from a Skype account that he had with a third party in Brussels. Another judge was removed from the first case. None of the original judges in the first trial ended that trial at all. The people who found the first defendant guilty, Saadi, none of them had started the case. How would you like to be put on trial by three people who turn up at the end of the trial to say guilty as charged?
Not having heard the evidence.
Absolutely. Yeah. And so a creature of political will was present right from the beginning, and that infected the whole subsequent dealings of this tribunal, because the subsequent judges who were put in were placemen for the government. The defence have been restricted to calling less defence witnesses than there are counts on the indictment. The last 3 trials, the defence have been restricted to 3 witnesses, 4 witnesses, 5 witnesses, without any restriction on the prosecution.
Is there any appeal against these judges coming in and their integrity and so on?
You are unable to question the impartiality of the judges by the founding statute of the tribunal. Neither can the prosecutor question them. But you are unable to raise simple human rights issues in your defence. Now, what has happened here is that the Supreme Court judges who've been appointed are, of course, all part of the same chain. And there's no interlocutory appeal. The time to appeal was reduced from 30 days to 15 days to prevent an effective appeal. Representations were made by that prosecutor in court that have been founded to be untrue, false, that witnesses weren't available. Witnesses were available for the prosecution who didn't want to testify with false testimony. It's been a shocking category of errors, and it does bring shame to the memory of those who have suffered in a conflict, who have suffered at the hands of war criminals. And that is not the desired outcome for a court.
Well, that's one of the points we'll come on to in the second half of the programme. We've got to take a short break. Stay with us. We'll be talking about that and also about the way the whole system has changed to bring in the death penalty, even though the original judges had not given that as the sentence. Stay with us.